So I'm Lizzie O'Shea, and I'm a lawyer at Morris Blackburn, and I run a public interest litigation section there. And I've asked you this question actually before, Larissa, I think at a conference about pro bono last year. But what I put to, because it was during the period of negotiating the minority government, and what I put to all three of the representatives from the major parties there, I would classify you now as part of a major party, is what can we do? I do think litigation's got a role to play because it can open the door for politicians then to take action. And I'm obviously a litigator, so I like litigation. But the problem is, I think, adverse cost risk is a huge detractor to bringing public interest litigation in environmental matters. It's also a detractor in lots of other situations, and I lose a lot of clients because they don't want to take that risk, and I fully understand that. That's something that seemingly has support from the Labor Party. Mark Dreyfus in that panel said that he supported the idea of public interest cases having a limitation from adverse cost risk, and I think that would be a great thing to put forward as a way of putting a limit on legal aid, or a condition on legal aid funding, that in practice in states that there should be caps on adverse cost risk at the very least, or immunity from it, as it exists in New South Wales. It has a very real impact because, as you will know, the New South Wales EDO is much bigger and does a much better job because of the provisions that exist in that legal aid scheme. And it's a really practical way to be able to foster political change in this area and other areas as well of law. So I would ask how we're going to push for that, how you're going to push for that. There's certainly demand from the legal community. Can you tell me what the Greens are going to do about getting that in as part of policy?
Yeah, well, we'll certainly do our darndest, but I'm hoping to get environment portfolios. I believe I won't end up getting the Attorney General portfolio, although it hasn't been finalised yet. So we'll be pursuing it in both of those aspects because, as you say, it's not just an environmental problem. The problem is community members can't afford to enforce the law when governments don't. And that's because the legal aid provisions are so restricted, and it's also because of those threats of having to pay the other side's court costs if you lose, because as we know, the general rule in most courts is costs follow the event. Now, there's some jurisprudence that says, okay, in public interest cases that isn't necessarily the case, but there's been quite mixed decisions in recent years, so people are feeling understandably less than confident about their own liability if they take a public interest case. So it all adds up to it being a huge disincentive for community enforcement. And that's a big problem, particularly when government isn't doing adequate enforcement in environmental areas particularly, but probably also in other areas. So that was one of the things that unfortunately I ran out of time to mention. It's certainly something we'll be pursuing in the Environment Protection and Biodiversity Conservation Act, which is those federal environment laws that I spoke of, making sure that security for costs orders aren't used to essentially shut down court cases. I mean, I think most of you are lawyers here, so I won't go into describing the what that is, but I'll assume that people acknowledge that and understand that. So there's security for cost risks, and then there's also costs in the event risks. So we want to fix that for public interest cases at least, and certainly in other areas of law, it needs fixing too. But as I said, unfortunately, unless you have the support of one of the other major parties, we don't have the numbers on our own to get laws through. So we'll certainly be working with the government of the day, of course, currently Labor. I don't quite know how long that's going to last, but, it's looking okay at this point in time. But we'll work with the government of the day on that. I haven't started yet, so can't really tell you more about what it is we're already doing, but it's certainly something that I will be pursuing in those environment laws myself, and I know it's certainly on our radar already, and we're keen, given people like Mark Dreyfus who have a legal background and who are conscious of community constraints, keen to see some results on that.
Ian, you spoke a lot about civilised values, and there's been a bit of work by Derek Jensen, a bit of literature trying to basically smash the civilisation paradigm, and to say that radical action is needed and that perhaps we need to go back to understandings of our relationship with nature closer to Indigenous law. And I guess we'll probably hear about it later as well, and you spoke a bit about Indigenous law. Do we perhaps need to be looking to treaty with Indigenous people and look to a new conception of what an Australian constitution might look like, which is based on an understanding of the first peoples of this land? Is that where we need to go back to? Is that the radical overhaul that we need? The Greens were talking, both of you today, talking about radical overhauls and really interrogating the rule of law. Do we really need to go back to that starting point of listening to the Indigenous peoples of this land and making an agreement with them about how we're going to treat it in order to move forwards?
As a non-lawyer, I'll defer to the lawyers about the issue of a treaty, but it seems to me as a non-lawyer that the whole of European occupation of Australia is based on theft, because the principle of terra nullius, the technical term is bullshit, I think, that the land was occupied, and it was assumed by a process that can only be called robbery with violence, and unless there is some formal recognition of prior ownership, and I would like to see it formalised as a treaty, we are the living benefactors of that act of larceny. In terms of recognising their values, I mean, I think maybe part of the problem is the word environment, because that suggests surroundings of which we're not part. And I think the fundamental point is that we are just as much part of natural systems as gum trees or galahs or goannas. Like them, we depend on natural systems for nutrients, and we depend on natural systems to process our waste. I mean, if you think about it, every molecule in your body, unless you've been to a fast food joint lately, was once part of the natural systems of this planet. And every molecule in your body will in time again be part of the natural systems of this planet. We depend on natural systems for what is absolutely essential: the air we breathe, the water we drink, the food we eat, our sense of cultural identity and spiritual sustenance. So unless we maintain the integrity of natural systems, we have no future even as a species, let alone as a civilization. So I agree with the fundamental point that we should be reinventing our legal system, recognising the primacy of the need to maintain the integrity of natural systems. And rather than saying that economic development can go ahead unless you can prove that it damages the environment, we should say the ecological systems could go ahead, and those who want new economic developments have to prove that they are consistent with that broader duty of maintaining the integrity of natural systems. But I'll hand it over to the lawyers.
I entirely agree that the way ahead is to do as the Ecuadorians have done, and to start from the highest principled legal document in the country and enshrine the principles that we want to see. And clearly there is currently the proposal on the table to have the Indigenous first ownership recognised in the Constitution, and that's a positive thing. But the reason I made a reference to the environmental provisions now appearing in constitutions around the world is that is a model that we should follow. And it's not because I naively believe that overnight it's going to change. Of course it's not, because societal decisions will be made in the context. But I need a better context to argue the case. And hence, it's a filtered down process. And so the more you get those high principles appearing in legislation, every piece, every preambular statement in all legislation should recognise the high principles that we adhere to, whatever they will be. Personally, environmental principles should be a paramount one. For legal profession, for instance, we've all those who are lawyers have been trained on the ethical, to recognise the ethical standard, to see duty to the law, duty to the client, duty to the court. In my opinion, and I was the subject of a paper I delivered to National Environmental Law Association 20 years ago calling for it, I think there should be in that hierarchy a duty to the environment. And some of us would argue that it's first and foremost, because that is the context within which the whole of our society and the whole of all other biodiversity exists. And so it is not right for people to be practicing in law or in any other discipline unless you have that environmental context at the back of your mind, which sets the framework. A few of us, when we founded the Environment Institute of Australia some years ago, we decided to put in a code of conduct which had to be signed off if we were going to be allowed to become a member. And they were the first principles of the Rio Declaration we incorporated. But the next evolutionary step was to move towards a certified environmental practitioner. So you effectively, the aim is, so you can't actually practice as an environmental engineer or environmental scientist unless you have been certified and do your annual update of awareness of principles and training. And that's gradually coming across. We're seeing it. I know it may be slow, but by gosh, we've come light years from where we were.
Look, I don't have terribly much to add to what's already been said, other than to say that, yes, that was one of the things that we insisted on in exchange for supporting Labor to form government, was a referendum on recognising Indigenous people in the Constitution. So that's certainly something that we've actively pushed for, and we're now involved. Our Senator from WA, Rachel Seward, is now on the panel that's looking at, well, what might those words be, certainly in consultation with Indigenous communities as well as the wider community. So yes, we're working on that, and that's really important. I also think, as has been said, that it's important that we have a recognition of the primacy of the environment in our Constitution. It's been more than 100 years now since that document was written, and yes, it's still relevant, but probably does need a bit of tweaking. And certainly with the things that I mentioned before, the fact that at the moment our federal government can only deal with the environment if it fits into those arbitrary categories, I think that's unsatisfactory. I think that doesn't fit with how science or nature works. I would like to see that included. I don't know if I have any company in that regard. I'll certainly be talking with my colleagues about that, and I don't know if it's going to happen in the short term, but the Constitution is the document which sets the tone for all of our other laws. And I guess coming back to Lizzie's point, litigation is a fantastic tool, and it as I said before, the law's okay. Some of our environmental laws are okay, and we need to use those and what rights we do have, what rights the community does have, to get good outcomes. But when you come up against climate laws, given that there are none, effectively, apart from some local council decisions about sea level rise, which are really good, but in Queensland there's no state law, and certainly there's no federal law to limit emissions, then you can't litigate against that. You need the law changed. So we need both. We need litigators pushing the bounds of what the law says to try and make it fit modern circumstance, and then we need people in Parliament making sure that our laws fit modern society and protect this planet for the rest of us, including animals and our kids.
Thanks, Larissa. There were many more questions, but the fundamental duty of the chair is to make sure that we get to lunch on time. So I'm going to draw formal things to a close, reminding you that Larissa and Simon and I will be in the room at the back to chew on this. So bring your Samo and join us if you want to keep rapping about those issues. Can I, at the end, remind you where I finished my presentation, and remind you, as we used to say at the Commission for the Future back in the days when we had a government that was concerned about the future, that the future is not somewhere we're going, but something we're all creating. And if you want a better future, you need to be working positively for it, because what we do today will determine what sort of world we live in tomorrow. Please join me in thanking Simon and Larissa.